Probable cause. We've heard this word so much, it's very much like a deadbeat horse. But oftentimes, most municipal police would not have probable cause to seize, search, arrest most of the people that they deal with. And because of this, it is well understood from trial and error over many years by the judicial system, and they've incorporated the probable cause finding into the judicial process. And most people don't know this. Most people are oblivious to this. But even more important is the time period. The probable cause must be done within 48 hours, and in some cases 32 hours. So most of you who you know very well that you did not commit a crime, you've screamed it over the top of your lungs a million times that you didn't do it, that no crimes exist. Yet here you are being charged, you pled guilty, you're on probation, you did one thing or the other against your own will, and even if you did it with your will, you would not have done it had you known better. Here it is, and here's your solution so that it doesn't happen again, or if you are seeking recourse against those who trespass against your secured rights, you need to know this. It's a stare decisis called County of Riverside versus McLaughlin. It was decided by the U.S. Supreme Court in the year 1991. So if anyone wants to bring up some stare decisis about probable cause and judicial proceedings and due process, and you're bringing it from 1980 something, 1950 something, and then the attorneys or the acting judge is saying, well, that's a long time ago, it's been overruled. Maybe they're right. As far as my research go with this one, this is more recent, and it has not been overruled. It stands, and final decision is at the Supreme Court level, and it was reaffirmed by the appeals court, which is certiorari, which is appeal on a Supreme Court level. The summary of it is, whenever any man or woman is arrested and it's still somehow vague and there's some type of dispute that probable cause existed, there exists a 48-hour window, and in 2 days, and in some case less, 32 hours, for a judicial determination to remove that dispute and say yes, a probable cause existed for this arrest or not. The steps you take after that is up to you, if the judicial process favors you. Now, the interesting thing is, it doesn't occur that way. If you do get a hearing to stand in front of an acting judge, you will be going to a bond court, a bond judge that's going to say, all right, we're going to release you on your own recognizance. Come back and show up in court date. They say and deal with nothing as it pertains to probable cause of why you were handcuffed, put in that cold and dirty, filthy cell. They just go through the motions just like they did with the last 3,000 men and 3,000 women. Get in there, okay, blah, 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 this happened. They state out everything as though that's an admission of guilt. Then they release you on your recognizance and they push you through the judicial process and then get you to plea and you get your ass kicked. All right. But do know that none of that is lawful, because the moment you're standing in front of a magistrate or an acting judge, the only thing that should be discussed is whether the arrest itself is established or founded upon probable cause or not. None of that has been discussed within 48 or 32 hours, then that's a whole nother trash that you're dealing with on the side. And the onus is on you to bring that up and to hold people liable. But nonetheless, here's the reason why that is. County of Riverdale versus McLaughlin. There goes the reference. United States Supreme Court, County of Riverdale. So we'll just look at keywords here. in order to satisfy Gerstein's promptness requirement, the jurisdiction that chooses to combine probable cause determination with other pretrial proceedings must do so as soon as is reasonably feasible, but no event later than 48 hours after arrest. Providing a probable cause determination within that time frame will, as a general matter, immunize such a jurisdiction from systemic challenges. Jurisdictional challenge. Although a hearing within 48 hours may nonetheless violate Gerstein, which is a standard, if the arrested individual can prove that his or her probable cause determination was delayed unreasonably. Meaning if they take you to a bond court and they just release you under recognizance without even determining whether the arrest was lawful or not, they're just going through the motions as though you're guilty already, then there's no presumption of innocence before guilt. And this applies. Again, although a hearing within 48 hours may nonetheless violate Gerstein, if the arrested individual can prove that his or her probable cause determination was delayed unreasonably. Courts evaluating the reasonableness of delay must allow a substantial degree of flexibility, taking into account the practical realities of pretrial procedures. That has nothing to do with you just going into bond court. That first magistrate or acting judge you see should be determining the probable cause of your arrest, not just taking you through the motions of, okay, now sign this bond to admit guilt. Because when you sign that bond, you have in fact admitted guilt, and you have in fact created your first ever appearance in court through that bond. Not when you physically go in or any of that. That's why usually they don't even send you summons, because you already put your hands into that contract. Where an arrested individual does not receive a probable cause determination within 48 hours, which 10 out of 10 times they don't do. Only very rare circumstance do they ever do it, which will be the exception. The burden of proof shifts to the government to demonstrate the existence of a bona fide emergency or other extraordinary circumstances, exigent circumstance, which cannot include intervening weekends or the fact that in a particular case it may take longer to consolidate for trial proceedings, meaning time periods and other factors that might prevent them from determining the probable cause of that arrest within 48 hours. Meaning if they did not determine the probable cause within 48 hours, then the case must be thrown out. If they did, then they can start talking about, okay, sign a bond to be released, and here's your next court date. When was the last time you've ever had a probable cause hearing before signing that indemnity bond? Think about it. So just articulate that you need that probable cause finding, and they'll try to just skip through it because they're used to just going by it. At least you articulated that. Now take that and use it as your cause of action in your counterclaim. That's why none of that proceeding is valid. Everybody's always upset that these acting judges always want to put liens in them and sue them. If you don't know these foundation of what they're supposed to be doing, you can do all the non-UCCs and UCCs you want all year, all day. It is not going to have any effect. In fact, it jeopardizes your safety and your livelihood, because you just threading in very, very high tides. You are clueless. You're going on a sailing boat and you don't know the basics of what it means to sail, and you're at high tide, and you're the first one to hark and bark about function in the admiralty jurisdiction, this and that, and you don't know these basics. All right. It then goes to show certain exceptions. Although the county, we can consider this to substitute this with other entities. Although the county is entitled to combine probable cause determination with arraignment, meaning they can just go with it during pretrial proceedings and have you appear through summons and all that. Although they can do that, it is not immune. They are not immune from systemic challenge. Challenge the constitutionality of the proceeding. That's an estoppel. Stops everything. An injunction right there. Systemic challenge is also a counterclaim, bringing that same 48-hour period up on top of whatever other claims you're bringing. So keep that in mind. Its regular practice exceeds the constitutionally permissible 48-hour period because persons arrested on Thursdays, which is the weekends they've mentioned up here, may have to wait until the following Monday before receiving a probable cause determination. Meaning the presumption here is they will, and they usually do create probable cause hearing. But the weekends and the holidays might matter and all that, all that cheesy crap. But what if you were never even given a probable cause hearing in the first place, which applies to most people? This should be part of your claim. And they're required to do it within 48 hours, according to the Supreme Court case. Use this case law. And the delay is even longer if there is an inconvenient holiday. Moreover, the lower courts, on remand, meaning they return the case back to lower courts, must determine whether the county's practices as to arrests that occurred early in the week, whereby arraignments usually take place in the last day possible, is supported by legitimate reason or constitutes delay for delay's sake. Now let's go on to other details. It goes on to say, the court then proceeded to the merits and determined that the county's policy of providing probable cause determination and arraignment within 48 hours was not in accord with Gerstein's requirements of determination promptly after arrest, because no more than 36 hours were needed to complete the administrative steps incident to arrest. They do a police report, they do the cabs report, they do the mug shot, they cross-reference the FBI files, the CIA files, they create their own internal file number, they send it to the state attorney's office, they create other back-end bonds on a municipal level, they contact the banks, the Lloyds of London, all these other, they do all that administrative stuff, right? It doesn't take more than 36 hours for all that to be done. So that leaves a window of about 12 hours for them to, after dealing with all the paperwork, that's what they're saying, just the paperwork of the employees passing paperwork, from one hand to the other. Let's just say worst case scenario, it takes 36 hours for them to do all the paperwork. They have 12 hours after that to make sure that you are afforded due process of determining, okay, we have all these claims in front of us, all these paperworks. Was it constitutional? Were you even supposed to be arrested in the first instant or not? They never do that probable cause hearing. Now keep in mind, although they can institute it or kind of blend it into the process of, okay, now go to the court and appear in the summons, and before you begin to argue the matter or put all whatever you want to put in, we'll just somehow incorporate the whole probable cause into the hearing of whether you're innocent or guilty. And that's a rare occasion. And usually they didn't really go into details of why and how, but more so, here's the truth. If you did not bring it up, you waived it. If you're not doing other systemic challenges that they mentioned, such as constitutional challenge, estoppel, or a counterclaim, you waived it. So if you're over here dabbling around pussyfooting, you're screwing yourself over. Know what you are doing, so that when you begin to do some financial things to hold people liable, so that you begin to engage in garnishment, levy, and attachment process against them, that's if you know what you're doing, then it would have validity, because your claim that serves as foundation to all that is firm. And then you have case laws backing it up on appeals level, and they have standards for that. called the Gerstein's requirement. All these things are in your favor. All these things are in your favor. By contrast, the Second Circuit understands Gerstein's to stress the need for flexibility, meaning, okay, there's an exception to the 48 hours, and to permit the state to combine probable cause determinations with other pretrial proceedings, which is what I just explained. There's the case laws that gives that exception, which was prior to this one, which is this case law, which gives the exception is in 1989. This case law that says, look, they need to do in the 48 hours is in 1991. And this is appellate case law we're talking about here. We granted the certiorari, which is appeals level on the Supreme Court level, to resolve this conflict, meaning, all right, any previous presumption that they can incorporate probable cause hearing into the whole pretrial hearing of, okay, now come into court and then we'll, in the process of determining whether you're guilty or not, we'll see whether the probable cause existed or not. To me, that's contrary to due process. Why should you even be going into court to see whether you're guilty or not if probable cause was not even determined in the first place and reasonable opportunity exists for that to have been done in the first instant? So now these guys are saying, well, even though we know they're saying they can incorporate the probable cause hearing into the whole process of determining whether he's guilty or not, they say we grant certiorari, meaning the highest level you can take any case, well, I won't say any case, but most case at North America, constitutional judicial system, the certiorari to resolve this conflict among the circuits as to what constitutes a prompt probable cause determination under Gerstein, which is a standard for prompt probable cause after an arrest. As an initial matter, the county, and substitute this word county for any other entities that arrest you under suppositions that you've committed a crime. As an initial matter, the county renews its claim that plaintiff lacked standing. It explains that the main thrust of plaintiff's suit is that they are entitled to prompt probable cause determination, right? Which you could possibly be doing, right? And they will try to come at you and say, well, you don't have standing. All right then, let's see. And insist that this is by definition a time-limited violation. Once sufficient time has passed, the county argues the constitutional violation is complete because a probable cause determination made after the point that makes reference would no longer be prompt. Thus, at least as to the named plaintiffs, there's no standing because it is too late for them to receive the prompt hearing, and under Lyons, they cannot show that they are likely to be subjected again to the unconstitutional conduct, meaning you fail to mention it at that point. Well, tough luck. There it goes back to the fact that you have to invoke your constitutionally secured right. Don't just keep quiet and during the process of all that going on and then later you try to bring it up. No, you have to invoke it. And if they willfully neglect it, that gives you more opportunity to use as an ammunition that, look, I invoked my right. I didn't waive it. If you keep quiet to it, then there's a presumption that you have waived it. And that is basically essentially what this municipal entity and their representatives are bringing in to say that, okay, you waived your right in so many words without really using those specific verbiage. So now they're saying your rights have statutes of limitation if you don't invoke it. That's basically what's going on. And the court is saying, well, we reject the county's argument. At the core of the standing doctrine is the requirement that a plaintiff allege personal injury fairly traceable to the defendant's allegedly unlawful conduct and likely to be redressed by the requested relief. Meaning, oh, well, you're saying he should have invoked the right. But the fact that he pointed out what could have happened based on the law and the foundation of why all these entities exist and all the municipal entities exist, then he's right. He pointed to a constitutional right, and that was all that was required. And he claimed that he was personally injured by that act. Now, in my words, who knows? Maybe he was not in the right state of mind. Maybe he was in shock. He was under threat. He was under duress. He was stressed out. Who knows? But all that matters now, according to what they're saying, is he pointed out that he was personally injured because of your unlawful conduct, which we, according to all these preemptory stuff that we've mentioned, should have taken place, but she didn't do it. The county does not dispute that. At the time the Second Amendment complaint was filed, plaintiff James, Simons, and Hyde had been arrested without warrants and were being held in custody without having received a probable cause determination, prompt or otherwise. And for lack of a better term, they fucked up. Not these guys, but the one holding them. Plaintiff alleged in their complaint that they were suffering a direct and current injury as a result of this detention and will continue to suffer that injury until they received a probable cause determination to which they were entitled. Plainly, plaintiff's injury was at that moment capable of being redressed through the injunctive relief. There you go. The county's argument that the constitutional violation had already been completed relies on a crabbed reading of the complaint. Meaning, we don't really care about what you're saying. We're just going to interpret it the way we want, which is what they do all the time. This case is easily distinguished from Lyons, in which the constitutionality objectionable practice ceased altogether before the plaintiff filed his complaint. It is true, of course, that the claims of the named plaintiff have since been rendered moot. Eventually, they either received probable cause determination or were released. Our cases leave no doubt, however, that by obtaining class certification, plaintiff preserved the merits of the controversy for our review. In factually similar cases, we have held that the termination of a class representative's claims do not move the claim of the unnamed members of the class. You know the beautiful part about class actions? It is an injunction. Whatever the decision is, it applies to anyone else that will be dealing with that case perpetually, especially if it's an appellate court on a Supreme Court decision, either in the state or federal level. In this case, federal level. They're telling you, since it's a class action, it applies to everybody else under similar circumstance. Use this case law. Use it. Use the verbiage here to state a claim when you do your counterclaim, when you do your tort, when you do your civil rights, when you do your discrimination claims. Use it. It's right here. If you don't, they will take advantage of you and they will run over you. There are tools out here for you to use. So read this case law. It gives you a lot of excellent points. This County of Riverside versus Lee McLaughlin. And it took place in the year 1991. United States Supreme Court. Certiorari to the United States Supreme Court of Appeal, 9th Circuit. This is as good as it gets. In summary, if you are arrested and within 48 hours, there's no formal probable cause hearing, and they just throw you through the motions and say, okay, you're released on I-bond, come back in this date for court. That is an open field for you to bring a claim right there. And this is a appeals court that makes final determination of judicial decisions that you can use as a tool. Get a certified copy of this, admit it into evidence through judicial notice. It's undisputable. Pair it up with the United States Constitution if you're in a federal court. If you're in a state court, pair it up with your state constitution. These tools are out here for you to use. Don't let it go to waste. Good luck.